Hi, Assalamualaikum warahmatullahi wabarakatuh. So this is Group 1 from Class 5F presenting assignment question 1, which is trade union is an association or workers' employers set up within particular trade, occupation or industry or TOI. The question is describe rights of a trade union as stipulated in the Trade Unions Act 1959. So before I start, allow me to introduce my group mates. The first presenter would be me. My name is Nur Afika binti Muhammad Khair. And second presenter is Siti Nur Shafika binti Abdul Razak. Third presenter is Nur Izzati binti Rosli. Fourth presenter is Rosila binti Muhammad. And last but not least, our last presenter is Nur Faradayana binti Abdul Hamid. So, as the first presenter, I'm going to explain a little bit about the introduction and focus more on the history of trade union. Basically, trade union is an organization that works in a trade, a group of trades which is formed to protect everyone's rights and interests. As we all know, Malaysia is well known as a country with multiple races ever since the phase of British colonialism. Before independence, Chinese and Indian work in the private sector in the rubber plantations and at the mines, while Malays works more as a civil service or would rather make themselves self-employed, work at the farm or go fishing. The public sector back then used to be known as General Labour Unions or GLUs. This GLU membership were actually open to anyone with no restrictions, unlike what we have today. These GLU were generally formed in different areas all around Malaya. They fight for their rights, and in history, they've shown many actions were actually taken by GLUs. The movement was not only restricted to employee matters, but also in the role of political, economic and socio-cultural.
Assalamualaikum and hi, my name is Siti Nur Shafika and I will present about the definition of trade union. So, what is the definition of trade union? Basically, a trade union will refer to any organization whose membership consists of employees which seeks to organize and represent their interests both in the workplace and society, and in particular seeks to regulate the employment relationship through the direct process of collective bargaining with management. In the Malaysian context, the Trade Union Act 1959 defined a trade union as any association or combination of workmen or employer, the working place either in West Malaysia, Sabah or Sarawak, either permanently or temporarily within any particular establishment, trade, occupation or industry, or within any similar trades, occupations or industries, and share at least one of the following objectives. So the implication from this definition is a trade union need not to be called a union. Many unions call themselves association. This is particularly common where the members are professionals or senior officers. For example, the University of Malaya Academic Staff Association and the Association of Maybank Class 1 Officers, which is open only to Maybank staff classified as Class 1 officers. So all the unions of employers are labeled associations. For example, the Malayan Commercial Banks Association. There are 4 objectives according to the Trade Union Act 1959, which the first one is to regulate the relations between workmen and employer. This is to promote good industrial relations between the parties, to improve the women's working conditions and enhance their economic and social status, which benefits the workmen, and also to increase productivity, in which the employee will benefit from it. So this is achieved through a negotiation of a collective bargaining to conclude collective agreement between employers and employees. With the collective agreement concluded, the rights, working conditions will be enhanced, since the term or condition of employment in a collective agreement must be better or more favorable than any written law, and also the individual contract of employment. Furthermore, the productivity can be increased through bonus, and remuneration based on performance. Thus, the trade union, through collective bargaining mechanism, strives for better terms and conditions of employment for its members, which individual workmen otherwise are unable to obtain. Besides better wage system, social and health protection, it had resulted for more legislation related to labor rights and employment protection. The second objective of the trade union is to regulate the relations between its members. It means that either between workmen and workmen in the case of workmen trade union, or between employers and employers in the case of employer trade union. This is provided in the union's constitution, which laid down the general constitution of trade union. This is provided in the union's constitution, which laid down the general constitution of trade union, the obligation of its members. Trade union also play a role in developing workers' culture involving solidarity, understanding, corporativism, and compassion for one another at the workplace and the community at large, besides to encourage worker education and networking. Alright, next, the third objective of the trade union is trade union also plays a role in the conducting of or dealing with trade disputes and matters related thereto as provided in section 2C2. So trade union can be the reason why trade dispute arises. For example, when request of recognition by trade union was rejected by the employers. So in dealing with trade dispute, trade union can report to DGIR 20 for the dispute to be resolved. The trade union is also required to furnish with documents, information, and attend a compulsory conference if necessary. Alright, the last objective is provided in section 2C3, in which if there is no other choice, then trade union have to promote, organize, or finance industrial relations such as strikes or lockouts is any trade or industry, or provide the provision of pay or other benefits for its members during a strike or lockout. Strikes and lockout used to compel the employer and employee respectively to agree to terms and conditions of employment when the parties are unable to negotiate a collective agreement. So that's all from me. The next presenter will present.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Izzati binti Rosli from AM110 Now, I would like to explain about the rights of registered trade union. The first rights of registered trade union is legal action. Section 25 Clause 1 of Trade Union Act stated that a union has the right to institute legal action, and similarly the union too can be charged. However, a registered trade union may be sued or prosecuted under its registered name. Once a call is formed to create a union within a month, the appliance of registration must be made, according to Section 2. All unions need to register with Director General of Trade Unions. The steps should be completed and compulsory to follow because in order to complete the forming and registration of an organization. Section 25 Clause 2 of Trade Union Act refers to specified that an unregistered union can be charged under the name of its use or the name it is referred to. However, organization whose register has been cancelled or withdrawn could also be sued and prosecuted under the name by which it had been registered. For example, he may withdraw or cancel the registration if the union has ceased to exist. Section 25 Clause 3 stated that a deregistered union can be charged under the name it was formerly registered. Under Section 15, The Director General of Trade Union has power to deregistration or cancel the registration a union under certain circumstances, but it is not mandatory for him to do and to do so. For example, union's involvement is unlawful attack led to deregistration by Director General of Trade Union. The second rights of registered trade union is financial support. The financing of organization is extremely much supported by its members through price of admission payment and monthly membership subscription. According to Section 5, Clause 5 of the Trade Union Act provides that any fines imposed can be derived from the sales of its movable properties with related criminal procedure. However, any fine ordered to be paid by a trade union may be recovered by sale of any movable property belongings for the trade union. A union can expel a person if it is limited its membership and the person now not one in all those people anymore. The Malaysian government now provides financial assistance to companies to conduct trainings during slow periods so workers still be employed, such as SOCSO and Perkeso. Malaysia's aim to realize a high-income nation not only needed a quality workers but also quality employers because the workers' well-being and dignity were important for increased productivity.
Hi, Assalamualaikum. My name is Rosila Muhammad. I will present about representative in court proceeding. Okay, if disputes cannot be resolved through negotiation, the last effort to reach the settlement is through the legal action. The case can be taken to the enterprise court. Representative may hire lawyer or advocates to represent them. This right is given equally so that no one is harmed. During the proceeding, other than the Trade Union Act 1956, another act to be referred to is the Industrial Relation Act 1967. These two acts are interrelated. The decision of the enterprise court is indisputable, but the representative can file a civil suit in civil court. But all negotiation procedure between the trade union and the employer must be complete with before bringing the case to the enterprise court. Okay, now I will explain about industrial action. Industrial action usually happen when a dispute in the workplace can be resolved through negotiation. There are three main forms of industrial action. The first action is picketing. Picketing where workers refuse to work for the employer. The employee act is standing or marching in front of the workplace to protest in order to reveal their grievances to the public. Second action is strike. Strike is an action of stopping and refusing to do work by group workers. This group of employees together act in a unified way to restrict, reduce, delay, or terminate the execution of work related to their work. The third action is lockout. This is employer side. Employer will do a restriction, include the closure of the workplace, the suspension of work, or the refusal of the employer to hire employees to continue working in response to the dispute. It is done to put pressure on employees to accept the term of employer. If you are involved in industrial action against your employer, you will probably to be breach of your employer contract, and you are therefore unlikely to be paid when taking part in industrial action. However, you will be protected against by dismiss for taking industrial action provided your unions follows the right procedure when organizing it.
I am Nur Faradayana and I will be talking about the exceptions of Rights of Trade Union Act 1959. So, trade unions are possibly the most effective body for workers to join if they want to get protection from wrongdoings such as exploitation by their employers or if they want to improve terms and conditions at the workplace. Employees and employers can get many benefits from joining the trade unions that exist as per their trade, occupation, or industry. However, not all employees acknowledges the importance of joining trade unions according to their specification. There are still many employees and employers that are unaware of the benefits, hence they did not join any of the trade union. Not only that, the existing trade unions are also there are also existing trade union that did not register legally. According to Section 8, Subsection 1 of Trade Union Act 1959, it is stated that every trade union established after the commencement of this Act shall apply to be registered under this Act within a period of 1 month, reckoned from the date on which it is so established. Unregistered trade unions have a few disabilities. According to Section 20 of Trade Unions Act 1959, a trade union shall not enjoy any of the rights, immunities, or privileges of a registered trade union unless it is registered. The term immunity can be defined as security or an exemption of persons from various civil obligations or liabilities. In the context of trade union, immunity is the exemption of body or people in the body from civil obligations or liabilities. Section 21 of Trade Union Act 1959 states that no suit or legal proceeding shall be maintainable at any civil court against registered trade union. The exceptions to this regulation are the trade union is not immune from cases such as breaching a contract of an employment, interference with trade, business, or employment of others, and interference with the rights of others to dispose of his capital or his labor as he wills. In addition to that, the interpretation of Section 22, Subsection 1 is the registered trade union is immune from any tortious act allegation. Its trustees and officials are protected too. The employees, union trustees, and union officials are immune from civil suit in cases stated in Section 21 of Trade Unions Act 1959. Tort law is the principle of law used to redress wrong done to a person and provide relief from the wrongful acts of others, usually by awarding monetary damages as a compensation. The court will not entertain or hear such allegation unless in the case for breach of contract, such as compensation payment prior to retrenchment practices. These special treatments of immunity from civil cases and immunity from liabilities are only valid and applicable for legally registered trade unions. Last but not least, only legally registered trade unions have the ability to sue and be sued and also be prosecuted. According to Section 25 of Trade Unions Act 1959, it is highlighted about proceedings by and against trade union. In Section 25, Subsection 1, it is stated that a registered trade union may sue, be sued, and be prosecuted under its registered name. The only difference between the rights of registered trade unions with unregistered and deregistered trade unions are the latter trade unions have no rights to sue. Unregistered and deregistered trade unions cannot sue, but they can be sued and be prosecuted. It is proven through Section 25, Subsection 2, and Section 25, Subsection 3, respectively.
Okay, as for the conclusion, as we all know, trade union or any kind of organizations that brings out the same motive or have the same goals actually plays an important part that protects the human's rights and interest. It is also important because so that nobody can take advantage on anybody, especially when they feel like their power or relevance is being endangered. This actually includes the secure standards of improvement in pay, benefits, working conditions, or social and political status with legal act. This kind of organizations also actually provides general advice and support besides giving training for new skills. Trade unions also help them to impose or enforce their legal rights, mostly when these rights may be uncertain or under debate. In addition, these organizations also may support the employees if they feel that the psychological contract between workers and managers is breached and can help workers to negotiate the contract again if needed. This, in some ways, actually manifests a good environment among the workers and employers. So that's all from us. Thank you.